First Division, GR number 197797, August 9, 2017. Heirs of Jose Peñaflor, namely Jose Peñaflor Jr. and Virginia P. AGATEP, represented by Jessica P. AGATEP, petitioners, versus heirs of Artemio and Lydia de la Cruz, namely MARILOU, JULIET, ROMEO, Ryan, and ARIEL, all surnamed de la Cruz, respondents. Decision. Judge Perlas Bernabe. Assailed in this petition for review on certiorari are the decision dated February 18, 2011, and the resolution dated July 8, 2011 of the Court of Appeals, CA, in CA-GR SP number 110392, which annulled and set aside the writ of possession dated June 27, 2008, and notice to vacate dated June 18, 2009, issued by the Regional Trial Court of Olongapo City, Branch 72 in other case number 38-0-93, thereby reinstating herein respondents heirs of Artemio and Lydia de la Cruz, namely MARILOU, JULIET, ROMEO, Ryan, and ARIEL, all surnamed de la Cruz, respondents, to the possession of the subject property. The facts. Respondents are the successors in interest of the late Artemio de la Cruz, Artemio, who is the son of Nicolasa de la Cruz, the original owner of a parcel of lands situated at number 11, Ifugao Street, Barangay Barreto, Olongapo City, including a 2-story building erected thereon, subject property. On April 15, 1991, Nicolasa authorized her daughter, Carmelita C. Guanga, Carmelita, Artemio's sister, to mortgage the subject property to Jose R. Peñaflor, the predecessor in interest of herein petitioners, Jose Peñaflor Jr. and Virginia P. AGATEP, represented by Jessica P. AGATEP, collectively petitioners, in order to secure a loan in the amount of 112,000 pesos. As Nicolasa failed to settle her loan obligation when it fell due, Peñaflor filed an application for extrajudicial foreclosure of mortgage before the Regional Trial Court of Olongapo City, Branch 72, RTC, docketed as case number 0-0-91. After the requirements of posting, notices, and publication were complied with, the subject property was sold at a public auction, where Peñaflor emerged as the highest bidder. A certificate of sale was thus issued in his favor. The period of redemption expired without the subject property being redeemed. Hence, a final bill of sale was issued and registered in Peñaflor's name. Thereafter, the latter executed an affidavit of consolidation of ownership. This, notwithstanding, Nicolasa persisted in her occupancy of the subject property and refused to deliver possession to Peñaflor. The RTC proceedings. Seeking to enforce his right to possess the subject property, Peñaflor filed a petition for the ex parte issuance of a writ of possession before the RTC, docketed as other case number 38-0-93. On November 19, 1993, the RTC granted the petition for the issuance of a writ of possession. Nicolasa and Carmelita did not appeal the decision, thus the same lapsed into finality. However, the writ of possession was not enforced as Artemio filed a complaint for annulment of judgment before the same trial court, docketed as civil case number 15-0-94, annulment of judgment case, claiming to be the lawful owner and possessor of the subject property even prior to the mortgage. Artemio's complaint was eventually dismissed without prejudice on the ground of lack of jurisdiction. In April 1998, and thus after the mortgage of the subject property in April 1991, Artemio filed a separate complaint for ejectment against Carmelita before the Municipal Trial Court in Cities of Olongapo City, Branch 5, MTCC, docketed a civil case number 4065, ejectment case. In support of his complaint, he submitted 1. Miscellaneous sales application number 1-43407, filed with the Bureau of Lands, Olongapo City. 2. Deeds of real estate mortgage signed by Artemio, mortgaging the said property to one Rosita Bonilla. And 3. Certifications attesting that he had declared the subject property in his name for taxation purposes. Also, he submitted a notarized deed dated May 3, 1989, denominated as Waiver and Transfer of Possessory Rights, May 3, 1989, waiver, executed by Nicolasa, waiving and transferring all her rights and interest over the subject property in favor of Artemio. The MTCC granted Artemio's ejectment complaint against Carmelita, which was eventually affirmed by the court in GR number 150187. In the meantime, the proceedings in other case number 38-0-93 continued. On June 27, 2008, the RTC issued an amended order granting PEñAFLOR's application for a writ of possession anew. On even date, the RTC issued the writ of possession. Thereafter, the RTC issued a notice to vacate dated July 11, 2008, ordering Artemio to vacate the subject property. However, on July 23, 2008, Artemio and his wife, LYDIA de la CRUZ, spouses de la CRUZ, filed a motion to quash the writ of possession and notice to vacate, claiming that the said writ could not be enforced against them as they are strangers to other case number 38-0-93 who are holding the subject property adversely to the judgment obligor, that is, Nicolasa. Artemio's siblings, Sotero, Mario, and Clarita, all surnamed de la Cruz, and Charlie Guanga, Carmelita's son, likewise filed separate motions to quash the aforesaid writ and notice, claiming their rights over the subject property. Their motions were, however, denied by the RTC in an order dated December 5, 2008. Consequently, Sotero, Mario, and Charlie filed a joint motion for reconsideration of the said order, which was likewise denied by the RTC. Subsequently, the RTC issued another notice to vacate dated June 18, 2009, ordering the children of Nicolasa to vacate the subject property. Said motions having been denied, herein respondents, in substitution of their parents, filed another motion praying that the implementation of the writ of possession be held in abeyance, as they are third persons in actual possession of the subject property who are asserting rights adverse to the judgment obligor. The RTC likewise denied respondents' motion in an order dated August 14, 2009. Hence, prompting them to elevate this case to the CA via a petition for certiorari docketed as CA-GR SP number 110392. The CA ruling. In a decision dated February 18, 2011, the CA annulled and set aside the writ of possession and notice to vacate issued by the RTC. It held that respondents are holding the subject property adverse to Nicolasa, the judgment obligor. As basis, it pointed out that the evidence submitted by Artemio in the ejectment case all indicate that he was claiming ownership of the subject property, which was in his possession at that time. Further, the CA gave credence to the May 3, 1989 waiver, which showed that Nicolasa had already renounced all her rights over the subject property in 1989, or 2 years before she authorized Carmelita to mortgage the subject property. Hence, finding that Artemio's claim of ownership as against Nicolasa is at the very least bona fide and made in good faith, the CA ruled that the RTC should have desisted from enforcing the writ of possession against Artemio's heirs, herein respondents. The remedy, according to the CA, is not the implementation of the writ of possession, but for the purchaser or the redemptioner to institute ejectment proceedings or a reivindicatory action. Dissatisfied, petitioners filed a motion for reconsideration, which was, however, denied in a resolution dated July 8, 2011. Hence, this petition. The issue before the court. The main issue for the court's resolution is whether or not the CA erroneously set aside the writ of possession and notice to vacate issued by the RTC in favor of herein petitioners. The court's ruling. The petition is meritorious. It is well settled that the purchaser in an extrajudicial foreclosure of real property becomes the absolute owner of the property if no redemption is made within 1 year from the registration of the certificate of sale by those entitled to redeem. As absolute owner, he is entitled to all the rights of ownership over a property recognized in Article 428 of the new Civil Code, not least of which is possession or jus possidendi. Possession, being an essential right of the owner with which he is able to exercise the other attendant rights of ownership. After consolidation of title, the purchaser in a foreclosure sale may demand possession as a matter of right. This is why Section 7 of Act No. 3135, as amended by Act No. 4118, imposes upon the RTC a ministerial duty to issue a writ of possession to the new owner upon a mere ex parte motion. Section 7 reads, Section 7. In any sale made under the provisions of this Act, the purchaser may petition the court of first instance of the province or place where the property or any part thereof is situated to give him possession thereof during the redemption period, furnishing bond in an amount equivalent to the use of the property for a period of 12 months to indemnify the debtor in case it be shown that the sale was made without violating the mortgage or without complying with the requirements of this Act. Such petition shall be made under oath and filed in form of an ex parte motion in the registration or cadastral proceedings if the property is registered, or in special proceedings in the case of property registered under the mortgage law or under Section 194 of the Administrative Code, or of any other real property encumbered with a mortgage duly registered in the office of any register of deeds in accordance with any existing law. And in each case the clerk of court shall, upon the filing of such petition, collect the fees specified in paragraph 11 of Section 114 of Act No. 496, as amended by Act No. 2866, and the court shall, upon approval of the bond, order that a writ of possession issue, addressed to the sheriff of the province in which the property is situated, who shall execute said order immediately. In Spouses Arquiza v. CA, it was reiterated that simply on the basis of the purchaser's ownership of the foreclosed property, there is no need for an ordinary action to gain possession thereof. Indeed, it is well settled that an ordinary action to acquire possession in favor of the purchaser at an extrajudicial foreclosure of real property is not necessary. There is no law in this jurisdiction whereby the purchaser at a sheriff's sale of real property is obliged to bring a separate and independent suit for possession after the 1-year period for redemption has expired and after he has obtained the sheriff's final certificate of sale. The basis of this right to possession is the purchaser's ownership of the property. The mere filing of an ex parte motion for the issuance of the writ of possession would suffice, and no bond is required. In Asia United Bank v. Goodland Company Incorporated, The court observed that the ex parte application for a writ of possession is a non-litigious summary proceeding without need to post a bond, except when possession is being sought even during the redemption period. It is a time-honored legal precept that after the consolidation of titles in the buyer's name, for failure of the mortgagor to redeem, entitlement to a writ of possession becomes a matter of right. As the confirmed owner, the purchaser's right to possession becomes absolute. There is even no need for him to post a bond, and it is the ministerial duty of the courts to issue the same upon proper application and proof of title. To accentuate the writ's ministerial character, the court has consistently disallowed injunction to prohibit its issuance despite a pending action for annulment of mortgage or the foreclosure itself. The nature of an ex parte petition for issuance of the possessory writ under Act No. 3135 has been described as a non-litigious proceeding and summary in nature. As an ex parte proceeding, it is brought for the benefit of one party only, and without notice to or consent by any person adversely interested. Emphasis and underscoring supplied. Further, in BPI Family Savings Bank Incorporated versus Golden Power Diesel Sales Center Incorporated, BPI Family, the court remarked that not even a pending action to annul the mortgage or the foreclosure sale will by itself stay the issuance of the writ of possession. Furthermore, it is settled that a pending action for annulment of mortgage or foreclosure sale does not stay the issuance of the writ of possession. The trial court, where the application for a writ of possession is filed, does not need to look into the validity of the mortgage or the manner of its foreclosure. The purchaser is entitled to a writ of possession without prejudice to the outcome of the pending annulment case. However, Section 33, Rule 39 of the Rules of Court, which is applied to extrajudicial foreclosure of mortgages per Section 6 of Act No. 3135, provides that upon the expiration of the redemption period, the possession of the property shall be given to the purchaser or last redemptioner, unless a third party is actually holding the property adversely to the judgment obligor. In China Banking Corporation versus Espouses Lozada, it was held that for the court's ministerial duty to issue a writ of possession to seize, it is not enough that the property be held by a third party, but rather the said possessor must have a claim thereto adverse to the debtor mortgagor. Where a parcel levied upon on execution is occupied by a party other than a judgment debtor, the procedure is for the court to order a hearing to determine the nature of said adverse possession. Similarly, in an extrajudicial foreclosure of real property, when the foreclosed property is in the possession of a third party holding the same adversely to the defaulting debtor mortgagor, the issuance by the RTC of a writ of possession in favor of the purchaser of the said real property ceases to be ministerial and may no longer be done ex parte. For the exception to apply, however, the property need not only be possessed by a third party, but also held by the third party adversely to the debtor mortgagor. Specifically, the court held that to be considered in adverse possession, the third-party possessor must have done so in his own right and not merely as a successor or transferee of the debtor or mortgagor. The exception provided under Section 33 of Rule 39 of the Revised Rules of Court contemplates a situation in which a third party holds the property by adverse title or right, such as that of a co-owner, tenant, or usufructuary. The co-owner, agricultural tenant, and usufructuary possess the property in their own right, and they are not merely the successor or transferee of the right of possession of another co-owner or the owner of the property. Thus, in BPI family, the court ruled that it was an error to issue an ex parte writ of possession to the purchaser in an extrajudicial foreclosure or to refuse to abate one already granted, where a third party has raised in an opposition to the writ or in a motion to quash the same, his actual possession thereof upon a claim of ownership or a right adverse to that of the debtor or mortgagor. The procedure, according to Unchuan v. CA, is for the trial court to order a hearing to determine the nature of the adverse possession, conformably with the time-honored principle of due process. In this case, respondents, in their comment and/or opposition submitted before this court, claimed that Artemio de la Cruz validated his ownership of the subject property, including the two-story house erected thereon and other improvements, through a deed of waiver and transfer of possessory rights executed by his mother, Nicolasa de la Cruz, in May 3, 1989, which is attached and made an integral part thereof. However, it is apparent from the face of this document that the same was not an effective mode of transferring Nicolasa's ownership to Artemio, which could have thus given the latter an independent right over the subject property prior to its mortgage to PEñAFLOR. The May 3, 1989 waiver reads that I, Nicolasa de la Cruz, of legal age and residing at number 11 Ifugao Street, Barreto, Olongapo City, Philippines, do hereby by this presence freely and irrevocably waive, renounce, transfer, and quitclaim all my rights, interest, and participation over a parcel of residential lot, including all the existing improvements thereon, more particularly described as follows: a parcel of residential lot situated at number 11 Ifugao Street, Barreto, Olongapo City, containing an area of 450 square meters more or less, in favor of my son Artemio de la Cruz, likewise of legal age, and residing at number 11 Ifugao Street, Barreto, Olongapo City, Philippines, the above described property, free from all liens and encumbrances, that I hereby warrant peaceful possession of the above described property herein waive, binding myself to defend him, his heirs, successors, assigns from any lawful claims of any person whomsoever. By virtue thereof, Nicolasa supposedly waive, renounce, transferred, and quitclaimed all her rights, interest, and participation over the subject property to Artemio. However, a mere waiver of rights is not an effective mode of transferring ownership under our civil code. In ACAP v. CA, ACAP, it was ruled that under Article 712 of the Civil Code, the modes of acquiring ownership are generally classified into two classes, namely, the original mode, that is through occupation, acquisitive prescription, law or intellectual creation, and the derivative mode, that is through succession mortis causa or tradition as a result of certain contracts such as sale, barter, donation, assignment, or mutuum. By its terms, the May 3, 1989 waiver cannot be classified as any of these kinds of contracts from which Artemio could derive ownership of the subject property. It cannot be classified as a sale because there is no price certain in money or its equivalent, as a barter because of the lack of any other thing given as consideration, a donation because of the lack of animus donandi and even a formal acceptance, an assignment because of the lack of price, and or mutuum because it is not a loan. Neither can it be considered as an assignment either by onerous or gratuitous title, so as to conclude that Nicolasa had already lost her right to possess the subject property to Artemio prior to its mortgage. Notably, in ACAP, the court debunked the lower court's characterization of a certain declaration of heirship and waiver of rights to a contract of sale, holding that the private respondent therein cannot conclusively claim ownership of the property, subject of that case, on the sole basis of a waiver document which neither recites the elements of either a sale or a donation, or any other derivative mode of acquiring ownership. In the case at bench, the trial court was obviously confused as to the nature and effect of the declaration of heirship and waiver rights, equating the same with a contract, deed of sale. They are not the same. In a contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other party to pay a price certain in money or its equivalent. Upon the other hand, a declaration of heirship and waiver rights operates as a public instrument when filed with the Registry of Deeds, whereby the intestate heirs adjudicate and divide the estate left by the decedent among themselves as they see fit. It is, in effect, an extrajudicial settlement between the heirs under Rule 74 of the Rules of Court. Hence, there is a marked difference between a sale of hereditary rights and a waiver of hereditary rights. The first presumes the existence of a contract or deed of sale between the parties. The second is, technically speaking, a mode of extinction of ownership where there is an abdication or intentional relinquishment of a known right with knowledge of its existence and intention to relinquish it in favor of other persons who are co-heirs in the succession. Private respondent, being then a stranger to the succession of Cosme Pido, cannot conclusively claim ownership over the subject lot on the sole basis of the waiver document, which neither recites the elements of either a sale or a donation or any other derivative mode of acquiring ownership. Quite surprisingly, both the trial court and public respondent court of appeals concluded that a sale transpired between Cosme Pido's heirs and private respondent, and that petitioner acquired actual knowledge of said sale when he was summoned by the Ministry of Agrarian Reform to discuss private respondent's claim over the lot in question. This conclusion has no basis both in fact and in law, emphasis and underscoring supplied. Indeed, while the nature of the document in ACAP is different from the May 3, 1989 waiver, the principle remains the same. Artemio cannot claim any independent right over the subject property by virtue of a document that does not even purport to be an effective mode of transfer. According to the CA, the totality of evidence shows that Artemio is an adverse third-party possessor of the subject property. Aside from the May 3, 1989 waiver, the evidence consists of the following. 1. Miscellaneous Sales Application Number 1-4-3407 over the subject property, filed with the Bureau of Lands, Olongapo City on October 2, 1968. 2. Deeds of Real Estate Mortgage dated May 13, 1973 and October 13, 1968, signed by Artemio and mortgaging the subject property and the parcel of land on which it stands to one Rosita Bonilla. And 3. Certifications dated January 7, 1969 and May 22, 1989 of the Office of the City Assessor, Olongapo City, attesting that respondent had declared the subject property in his name for taxation purposes. After much reflection, the court finds that these pieces of evidence are actually inadmissible to prove Artemio's independent right of ownership in this case against the mortgagee, PEñAFLOR, and his heirs, as they were never submitted as evidence before the RTC in other case number 38-0-93. These pieces of evidence were those submitted and considered in civil case number 4065, which is the ejectment case against his sister, Carmelita. Therefore, PEñAFLOR was not given an opportunity to contest the genuineness and authenticity of these documents in these proceedings and also, with his own evidence, to rebut the same. Hence, to consider these documents against him in this case would surely violate his rights to due process. Moreover, it should be highlighted that these pieces of evidence were offered to prove one thing, and one thing alone, that Artemio had the better right to possess the subject property only as against his sister Carmelita. The court, in GR number 150187, entitled Carmelita Guanga versus Artemio de la Cruz, which is stemmed from civil case number 4065, recognized that the only question to resolve in ejectment suits, such as in this case, is he who between the parties has the better right of possession de facto over the disputed property. While the court did inquire into the question of the property's ownership, it explicitly clarified that it did so only for the limited purpose of determining prior possession. Thus, with this established limitation on ejectment cases in mind, it cannot be denied that the aforementioned evidence cannot bind even Carmelita, the opposing party herself, in civil case number 4065, on issues regarding ownership and much more. PEñAFLOR and his heirs, in a totally different case, that is, other case number 38-0-93, from which the present petition emanated. At the very least, the fundamental right of due process demands that PEñAFLOR, and now his heirs, be given an opportunity to challenge such evidence before they may be considered in any respect against him. In fact, the RTC in other case number 38-0-93 implicitly touched on this conundrum in its order dated August 14, 2009, when it held that oppositors heirs of Artemio and Lydia de la Cruz cited case pertains to an unlawful detainer case filed against them by Carmelita Guanga, which issue of possession had been ruled in favor of the said heirs and herein petitioners as not a party to the said case. Hence, said decision of the Supreme Court in that GR number 150187 does not affect yet herein petitioners not being in possession of the property then. In any event, none of those pieces of evidence submitted in civil case number 4065 would even satisfactorily show that Artemio had an independent title to the subject property enough to dispossess the mortgagee, PEñAFLOR, who had already consolidated his own title over the same. First, miscellaneous sales application number 1-43407 is only a sales patent application, which was not clearly shown to have been granted so as to vest in him title over the property. Second, the deeds of real estate mortgage are not documents which show the original source of the mortgager's own title. On the contrary, these documents already assume that the mortgager is the owner of the property, and thus could mortgage the same. And finally, the certifications attesting that Artemio had declared the subject property in his name for taxation purposes, that is, tax declarations, only constitute proof that the holder has a claim of title over the property, and are therefore not valid documents which would show his source of title. In fact, Nicolasa, too, had tax declarations in her name showing that she had a claim of title over the same property. To note, these documents were her own proof of ownership through which she was able to mortgage the subject property, appearing to be an unregistered land, in favor of PEñAFLOR. As above discussed, where a third party has raised in an opposition to the writ of possession or in a motion to quash the same his actual possession thereof upon a claim of ownership or a right adverse to that of the debtor or mortgager, as in this case, the procedure is for the trial court to order a hearing to determine the nature of the adverse possession, conformably with the time-honored principle of due process. Notably, when this opposition is made, the proceeding for the issuance of a writ of possession loses its nature of being an ex parte and instead turns adversarial so as to give, on the one hand, the third-party claimant the opportunity to present evidence of his title showing his independent right over the subject property adverse to the judgment obligor mortgager, and, on the other hand, the mortgagee the opportunity to rebut said evidence in order to sustain the issuance of the writ and gain possession of the subject property pursuant to his consolidated title. Jurisprudence describes that an ex parte proceeding merely means that it is taken or granted at the instance and for the benefit of one party and without notice to or contestation by any party adversely affected. Clearly, this is not the case when an opposition is made by a third-party claimant against the issuance of a writ of possession from which the court is compelled to now order a hearing to determine the nature of the former's adverse possession. In this case, the CA improperly considered the evidence submitted in a totally different proceeding, that is, the ejectment case, taken against an entirely different party, Carmelita, in reversing the RTC's issuance of a writ of possession in favor of PEñAFLOR. In fact, even if we were to feign ignorance of this clear due process violation, such evidence were, nonetheless, ostensibly insufficient to prove that Artemio has an independent right over the subject property adverse to Nicolasa, the judgment obligor mortgagor. Thus, whether the May 3, 1989 waiver is the true source of title of Artemio or merely one which fortifies his claim of independent title, the totality of evidence is still not enough to prove the same. In addition, records are replete with circumstances which diminish the veracity of Artemio's claim against PEñAFLOR. 1. In the annulment of judgment case, Artemio claimed that he applied for a sales patent in 1960, which was allegedly approved in 1968 by the Bureau of Lands per the miscellaneous sales application number 1-43407, dated October 2, 1968. He likewise claimed in that same case that his mother Nicolasa does not own the property. 2. Yet Artemio, and herein respondents, asserted that Nicolasa transferred her rights over the property in 1989 by virtue of the May 3, 1989 waiver. 3. Sotero, Mario, and Clarita, siblings of Artemio, and Charlie Guanga, Carmelita's son, filed 2 separate motions to quash the writ of possession, wherein they claimed that they, with Artemio and Nicolasa, co-owned the subject property. They allege that said property was part of the conjugal partnership of spouses DELA CRUZ. When Ireneo died in 1985, they became pro indiviso heirs of Ireneo's share to the property. 4. Mario, however, testified for Artemio in the annulment of judgment case, stating that Nicolasa does not own the subject property. Taken together, these events would show that A. Artemio's claim over the subject property is riddled with material inconsistencies, and B. Nicolasa's children, among others, Artemio, appear to have been taking several steps to prevent PEñAFLOR from taking possession of the subject property and defeating his consolidated ownership rights thereto, thus further casting doubt on Artemio's claim of ownership. In fact, it deserves mentioning that Artemio filed the ejectment suit in civil case number 4065 only in April 1998, or 7 long years after the property had already been mortgaged to PEñAFLOR in April 1991. Thus, it is equally doubtful that he even had possession of the subject property at the time it was mortgaged to PEñAFLOR. In addition, the RTC had already granted a petition for the issuance of writ of possession in favor of PEñAFLOR on November 19, 1993, or almost 5 years prior to the filing of the ejectment suit in April 1998, which decision therein respondents Nicolasa and Carmelita did not appeal. Hence, for all these reasons, Artemio cannot be considered as a third party who is actually holding the property adversely to the judgment obligor, that is, Nicolasa, so as to defeat PEñAFLOR's right to possess the subject property, which is but an incident to the consolidation of his ownership over the same. As a final word, it should be clarified that the purpose of a petition for the issuance of a writ of possession under Act No. 3135, as amended by Act No. 4118, is to expeditiously accord the mortgagee who has already shown a prima facie right of ownership over the subject property, based on his consolidated title over the same, his incidental right to possess the foreclosed property. To reiterate, possession being an essential right of the owner with which he is able to exercise the other attendant rights of ownership after consolidation of title, the purchaser in a foreclosure sale may demand possession as a matter of right. Thus, it is only upon a credible showing by a third-party claimant of his independent right over the foreclosed property that the law's prima facie deference to the mortgagee's consolidated title should not prevail. Verily, a mere claim of ownership would not suffice. As jurisprudence prescribes, the demonstration by the third-party claimant should be made within the context of an adversarial hearing, where the basic principles of evidence and civil procedure ought to be followed, such as 1. It is the claimant who has the burden of proving his claim. 2. The claim must be established through a preponderance of evidence. And 3. Evidence not presented or formally offered cannot be admitted against the opposing party. In this case, none of these principles were followed, for the CA considered evidence that were not only submitted in a totally different case against an entirely different party, but are also innately inadequate to, at least, prima facie show the source of the third-party claimant's independent title, all to the detriment of the mortgagee, who had already consolidated his title to the contested property. The reversal of its ruling is therefore in order. Wherefore, the petition is granted. The decision dated February 18, 2011, and the resolution dated July 8, 2011 of the Court of Appeals in CAGR SP number 110392 are hereby reversed and set aside. Accordingly, the writ of possession dated June 27, 2008, and notice to vacate dated June 18, 2009, issued by the Regional Trial Court of Olongapo City, Branch 72, through its decision dated November 19, 1993, in order case number 38-0-93, in favor of petitioners heirs of Jose PEñAFLOR, namely Jose PEñAFLOR Jr. and Virginia P. AGATEP, represented by Jessica P. AGATEP, are reinstated. So ordered. Judges Leonardo de Castro, Del Castillo, and Caguiwa concur. Chief Justice Sereno, Chairperson, C. Dissenting opinion.